Article 1 of the UN Charter. Let's see which principles we find there. So you may wish to read out Article 1, paragraph 2. Yeah, please.
Article 1 of UN Charter, paragraph 2. To develop friendly relations among nations based on respect for the principle of equal rights and the self-determination of the peoples, and to take other appropriate measures to strengthen universal peace.
Thank you very much. So is there a legal principle there which we can look at more detailed? Yeah, in Article 1.2 it talks about the principle of self-determination of peoples, right? So, first question here, if you look at it, is a principle. Is this a right? Is this a legal concept? Or is this just a political proclamation? The right to self-determination. Is this a legal principle? If you read the norm, not so clear, but in the jurisprudence of the ICJ it has become very clear that it is a legal principle. This has been decided many times now, the latest in the Palestine cases. So the right to self-determination is a self-standing legal principle of international law, enshrined in Article 1, paragraph 2 of the UN Charter. And it is also repeated elsewhere, namely in Article 1 of the UN Covenant on Civil and Political Rights and in Article 1 of the Covenant on Economic, Social and Cultural Rights of 1966, which are human rights treaties. So the right to self-determination is there and it belongs to peoples. Yeah. So next question for the lawyer is, okay, which peoples can rely on the right to self-determination? How do we know what is a people that can rely on this right? Yeah, please.
A group of peoples, I'm not sure about the exact definition anymore, but somehow distinct from other groups of people by language, ethnicity, religion, these kind of things.
So a group of people which have a common identity and which are also defined by some objective criteria such as language, culture, religion. Okay, so question, is a tribe in African country, let's say the tribe of the Maasai, is that a people within the meaning of Article 1, paragraph 2? It's a group, has an identity, language, religion. Is the tribe of the Maasai a people within the meaning of Article 1, 2? They have all criteria to be people, yeah, but they don't have their own state. Yeah? Why come? How come?
I can reply like, according to Article 1, sub-Article 2 of the United Nations Charter, the people referred here, are not only the people belonging to the certain ethnic group or certain tribe, they must be the people, even of different tribes, but as long as they have their own state, living within their own territory, like us here in Tanzania.
I think this is a correct reading. It's not giving the right to all tribes which have a common identity. Not all groups are meant by the notion of peoples. But how do we distinguish then? Which are the ones who can rely on it and which are the ones who cannot rely on it? Elvis?
The complication, where's Lucas? Lucas? Yeah, I hope you, you, you don't fall in this, because the complication is always like, I give these examples of the Catalonia, okay? Yeah, so that's why it doesn't affect you. So, it brings complications because when it comes to like the criteria that was given by the first speaker, which is very interesting, and the common ancestry together, so the Maasai would fit in all these criteria except for geographical boundaries. But then the geographical boundaries would come in where they determine to say, we feel like a nation. Yeah, because it is nation states that are given this right. But then you have to determine that. Now, this will to determine yourselves as a nation, if it becomes like an unruly horse, it will lead to balkanization, to the birth of so many states, and there will be no limit, you know, such that whenever there is greed and grievance, you say, okay, you are being greedy, you are not sharing the resources with us, I'm going to start my own nation, you know. So where do we put the end? So if you follow the case of Catalonia, you see, several times, different jurists have pronounced themselves on the case of Catalonia, because Catalonia is not only in Spain, it goes up to France, you see. So if you are going to grant Catalonia independence, it means that part of France also will be affected. But I think they don't only rely on that, they go in detail on these principles of self-determination when it comes to nationhood, you know, such that it becomes also political, you know. So it is not only the legal argument, but this is where the jurisprudence of law and politics intermarry, and that's how far I can go. Thank you.
Okay, so Elvis made an important observation here and says, look, if you are too generous in saying peoples, all groups which themselves as peoples, we would have a situation where you have a lot of groups within existing states who could claim this. And then he used a word which is often used in Europe, the Balkanization. I'm not sure that everybody knows what this means. Balkanization means the falling together into many little entities, yeah, which are then themselves weak and probably not very able to survive in themselves. Yeah, so you have a domino effect. If then you have rather than one functioning state, you have 10 very little entities, which all of them are too weak, and that cannot be in the interest of the stability of the entire region. So there is a certain caveat here, where you say, let's be a bit more careful. It cannot just be every group which has a common identity. Okay, so that's the reason behind one needs, as a lawyer, to be a bit cautious. But I'm still trying to find out how I can then demarcate. And you wanted to say that.
I will answer your question. I'm more going off of that. So I think the issue is not the definition of people itself, because from the right to self-determination, there's no direct right to secession. One needs a breach of the right to self-determination. And in the example of Catalonia, I would say that Spain has autonomous regions that do grant, especially for the right of self-determination. So the issue would not arise there. So I would say the point would not be the definition of people, but rather if the right to self-determination is breached. And in that regard also, if we connect the requirement of what people are to stated, it would make the right to self-determination somewhat irrelevant.
This brings another important point into the discussion. The argument is to say, well, maybe it's not so much a problem to accept that certain group is a people, but the more important question is what follows from that. Well, what is then the right of that people? Does then a people really have the right to an independent state? Or is there something, how to say, which needs to be distinguished? Yeah, I think I come back to that. I first want to bring to your attention that traditionally, yeah, if you look at the definition of peoples, the uncontroversial interpretation was it surely applies to people in a decolonization context. Yeah? So, peoples who have been colonized in the past have a right to self-determination. That has been also the historical background of where it all came from. So it was basically given or accepted that even if different tribes in a given colony would themselves define them as a people, and they could claim the right to self-determination against the colonial power. That was uncontroversial. Okay? The other thing is, well, what about then different groups within this kind of bigger entity? And here we come to what the colleague has just mentioned. Let's look a little bit at the right itself. And we traditionally make a difference between internal self-determination, meaning as a group you can have certain, how to say, autonomy in which you have a right to, let's say, define your religious usage, and that people can exercise their religion within nation, and that should be respected as a sort of internal self-determination. But the other side, the external self-determination, the right to found your own state and to declare independence or secession, right, would only very exceptionally come into play, namely when the right to internal self-determination is brutally suppressed. So in the case of Catalonia, for example, the argument was said that even if the Catalans can claim that they are a people on their own right, they have internal self-determination, which is granted, because under the Spanish Constitution there is a certain autonomy, and that's fine. They cannot claim, as a matter of international law, that they are so badly treated that their right to self-determination turns into a right to secession. Yeah? So that's the additional point, and it's a valid one. Yeah? Okay, so I think we leave it at this to understand a little bit the notion of Article 1.2, and now let's have a look at two very controversial cases where I think also the opinions may diverge between Europe and Africa, but also within Europe and within Africa. First case, Western Sahara. So, what is the current situation of Western Sahara? Does the people of the Western Sahara enjoy a right to self-determination? Yes or no? It depends. Please, have the mic, please.
It depends. If we consider that Moroccan occupying them or like use any kind of aggressive behavior towards them, then we can consider them people deserve self-determination. But if just a merge between Morocco and South Sahara without any kind of aggressive or obsession, then it will be okay.
All right, so we see already we need to know more about the history in order to reply to that question. And this was brought to the attention of the International Court of Justice in the famous 1975 opinion, advisory opinion on the ICJ. And the ICJ found, yes, Western Sahara, the people of Western Sahara do enjoy the right to self-determination as a distinct entity, but it also said how to exercise this needs to be agreed. Yeah? So it was clearly the ICJ did not say, and because of that they have a right for an independent state. This is not what the ICJ said. ICJ said there's a right to self-determination, and how this will be exercised remains to be seen. Okay, but that's the starting point. And now we know, of course, that parts of Western Sahara are effectively occupied and administered by Morocco, which then takes the view that this is in line with international law because they are the de facto administering power, and that's all right. Now, how does the African Union see that matter? Can somebody tell me whether there's a position of the African Union on the matter? How many member states do you have here? Sorry? Okay, and who is among those members? Morocco and No, not Western Sahara, but what is the name? Yeah, the Arab Democratic Republic of the Sahara, right? So it's a member state of the African Union, and this creates an obvious tension with Morocco, it's clear, right? But according to African Union, the Western Sahrawi people have exercised the right to self-determination, and they have founded and established an independent state which needs to be recognized and is a member of the African Union. Okay, but Morocco has a completely different view, and that leads to some tensions in bilateral but also in other areas. For that reason, Morocco also was not part of the African Union for quite some time and was only readmitted later on. What is now the position of the European Union? Well, the European Union has trade relations, in particular with Morocco. And as our colleague yesterday said, these are the famous association agreements. Association agreements exist also with, between the EU and Morocco. And there the question comes up, does the EU, when it concludes a treaty with Morocco, include also the parts which are currently under the Moroccan administration? And is it allowed to do so? Would that not amount to somehow recognition of the Moroccan sovereign title over the territory? Very difficult question. And this, very interestingly, came to the forefront. So the EU concluded an association agreement and then some protocols on fisheries and agriculture. And the solution was to say we don't define what is the territory of Morocco, but we allow that also fishery products and agriculture products from the Western Sahara territories can be treated under the agreement. And that solution, so to say, was attacked before the European Court of Justice. The Polisario movement, who describes itself as the representative of the Western Sahara people, the Polisario movement went before the Court of Justice in Luxembourg and said, this agreement between the EU and Morocco is against international law because you accept that Morocco is governing this part which it should not under international law. So, first, very interesting observation. The case does not go to the ICJ, but it goes to the European Court of Justice. And the Court of Justice was confronted with the question, okay, do they have standing? Can the Polisario Front bring a claim? And in this case, the court accepted that and says, well, they have a specific position under international law as a movement claiming to represent the Western Sahara people, so that's enough for me. So I hear the case. And next question is, what is the standard that the Court of Justice will apply? Because European Court of Justice will normally apply European law, right? But the claim was, the agreement you have just concluded, EU and Morocco, is against international law. Is this a valid claim that the European Court of Justice can hear? What do you think? It's a little bit EU law, but as a matter of your, let's say, assessment, the answer is yes. European Court of Justice says international law, in particular customary international law, forms part of European law. It is part of the norms that we as European Union have to accept and comply with. So I am also ready to check whether or not this agreement, bilateral agreement, is in line with international law. And in order to do so, I'm going to look at the significance of Article 1, Paragraph 2 of the UN Charter as interpreted by the International Court of Justice. So they use the ICJ jurisprudence as guidance for their own case. And then the court there's a number of things, and I have to be a little bit shorter because there were several cases. In the first case, it said very clearly so, under international law, Western Sahara is separate from Morocco. Therefore, the territorial application of the treaty cannot extend to Western Sahara in terms of sovereignty of Morocco. Morocco cannot claim to have sovereignty over Western Sahara, therefore the territorial claim needs to be limited to Moroccan sovereign territory. However, at the same time, is a possibility that there is a de facto administration also of territories outside your sovereignty. It is possible and it is accepted under UN law that you can have de facto administrating powers, which Morocco is currently exercising on parts of the territory. However, the de facto administrating power itself must comply with a couple of principles. And the couple of principles is that when you use the resources of that territory, for example, fish, or agriculture, you must have a system to ensure that the benefits, in other words, the money you earn with the exports, that the benefits somehow arrive to the local population. So even if there is a de facto administrating power, there needs to be a system that makes sure that the local population benefits from this kind of arrangement. And the people of Western Sahara must also have given consent to this kind of arrangement, either explicitly or implicitly. So this is a very interesting judgment because it interprets Article 1, paragraph 2 of the UN Charter in a fairly clear way, and it says, and I quote here, the implicit consent is only possible where the arrangement confers a specific, tangible, substantial, and verifiable benefit which flows from the exploitation of that territory's natural resources, proportionate to the degree of the exploitation. So European Court of Justice is very clear on the matter, and then looked at the agreement and said, where is this? Where is the mechanism which makes sure that there is benefit for the local population? I cannot see it, at least not sufficiently. There is a little bit in terms of distribution, but it was not clear and tangible. So the court annulled the decision to conclude the agreement. It's a fairly strong fairly strong thing. Based on international law, an agreement between EU and Morocco on that mark was annulled, and therefore there is a need to renegotiate that matter to make sure that those conditions are complied with. So I think that's an interesting and very important example to see how Article 1.2 is trying or is being interpreted in Luxembourg in this very concrete case. At the same time, I have to tell you that politics move on, and at the UN Security Council there was a recent resolution on the whole matter, and that is UN Security Council Resolution 2797 of October 2025. And in that resolution, UN Security Council says that in order to find a way forward on the whole Western Sahara issue, the Security Council considers that the so-called autonomy plan of the Moroccan government should be put in the center of the future efforts. So there is a certain shift in the UN Security Council on those matters, and we will see how this will play out. But this is not an EU decision, that's the UN Security Council. All right, any questions on this? Yes, please, sir.
Thank you, Prof. As we are discussing Morocco, there is also controversy about Ceuta and Melilla, which are on the African continent, but they belong to Spain. So what is the position of the European Union on that contentious subject?
Okay, thank you. So the question was raised on Ceuta and Melilla, and the answer can be fairly short. There is no EU position other than that Spanish sovereignty exists on the matter, and we are not going to doubt that. It's a matter of Spain and then whoever contends it's not part of it. So the EU stays out of this, in short. Yeah? Okay, good. Thank you for this. And the next very controversial case under Article 1.2, and we've discussed it, let's say, at the margins already, is of course Palestine. Yeah? What is the current situation of Palestine under international law? Can somebody make a summary? The occupied territories of Palestine and the state of Palestine. How would you relate that to Article 1, Paragraph 2 of the Charter? Somebody like to make a short summary? I see it's after lunch, but somebody takes the courage, please. Yeah, a volunteer here. Okay, then I will do my best. So currently what one can say is that the Palestinian territories have been occupied to a large extent by Israel, and parts of that have been reversed back under the Oslo Accords. And we have currently a administration, the Palestinian Liberation Movement and the authority. At the same time, there was the control of Hamas in the Gaza Strip. For some states, this was sufficient for recognition of the state of Palestine over those two parts, whereas others have doubts whether this is sufficient in terms of effective government exercise. And there's two different factions, the government under Mahmoud Abbas and Hamas and so on. So in short, the state of Palestine is recognized by a number of states, but not all. And the situation and the question then comes up, okay, what are the rights and obligations of Israel as occupying power? And what are then the rights and obligations of third states with respect to Palestine, even if they would not recognize it as a state? And these questions were triggered mostly in the recent opinion of the ICJ on the prolonged occupation of Palestine, and opinion 2024. And what did the ICJ say, roughly? It said, roughly speaking, the Palestinians have a right to self-determination under Article 1.2. The prolonged occupation is illegal. Israel has to withdraw, and other states shall not recognize any sort of sovereignty of Israel over Palestine, and should also make efforts to bring this into compliance. Now, what does that mean for the European Union's dealing with Palestine and Israel? First question, does the European Union recognize the presence of Israel in the occupied territories? No. We have a clear position that Israel borders cannot extend over the 1967 situation, and that the others which go beyond are then under Israel occupation and should be treated like that. So there's clear non-recognition of Israeli sovereignty over those parts. So this is very clear and settled. A little bit discomforting is, of course, the decision of some governments to place or to say we move our embassies from other places to Jerusalem. That is a little bit confrontational, because Jerusalem as capital of Israel could be seen as accepting that it's also rules over Eastern Jerusalem and so on. So that's a controversial move, but that's not an EU position. Some national governments have done that, following the US example, but certainly only a clear minority for the time being. So, in principle, non-recognition is a clear matter. But what about trade with the territories? Sorry? Is there something wrong here?
I believe that it's also mostly up to national governments. I know that at least some national governments have dealings that, similarly to Morocco and Western Sahara, include occupied territory.
This answer is it's a national matter, but I have to tell you that trade at the level of the European Union is an exclusive competence of the Union. So it's only the European Union which can decide what are the rules for import and exports with third countries. So the trade policy of the Union will have to respect, what is the sorry.
There's no transmission because the microphone is not there.
Okay, can I take this one? Yeah. All right. So, question is, the trade policy of the European Union vis-à-vis occupied territories is falling under European exclusive competence, which means that national governments cannot decide whether or not they want to have trade with a particular part unless the European Union authorizes it to do so. And therefore we have a common approach, and the trade rules are then laid down in an agreement that the EU has with Israel and an agreement that it has with the Palestinian Authority. So we have two different legal norms, and now in practical terms this means a little bit of a complication, because imagine you have a product which is produced in an occupied part, and Israel considers that part as part of its own sovereignty. So they would send, let's say, citrons, They would send citrons from a settlement to Europe and say this comes from Israel, because they believe that it's part of their sovereign territory. The Union does not think so. It says, no, it does not come from Israel, it comes from the occupied territories. But it is labeled as originating from Israel. And that is, of course, a problem. So one view and the other view do not coincide. And therefore we had a long discussion, and it was solved in 2001 to the following, to say, if they are products from the settlements, it is not enough to say coming from Israel. It has to identify the precise place, the labeling of the precise place, so that an EU customs officer can understand, no, it doesn't come from Israel, it comes from the occupied territories, and therefore I cannot treat it as an Israeli product, giving it trade preferences under the agreement. So we have a labeling, a distinction, to make sure that the products are not giving preferences under the Israel agreement. Now the ICJ said in the opinion something very important, and I quote here, the ICJ said also that all third states are under an obligation to avoid and to assist in the unlawful presence of Israel in the territory, and to take steps to prevent trade or investment relations that assist in the maintenance of the illegal situation. So, does that mean that there is an additional legal obligation not only to distinguish between the products, but maybe even to block them. So an argument could be made, if you allow a settler which is currently illegally settling in the occupied territory to send a product to Europe and earn money, you actually help the settler to remain there. So distinction, fair enough, but blocking is more effective to basically combat the illegal presence. And that's an open question where there is not a unanimous view in the European Union. Some will say, yeah, we should go further and block the import, and others would say, no, distinction is enough. And this needs at EU level a decision at qualified majority. And for the time being, the majorities are not there to go further than distinction. And in that kind of situation, a few states have said, okay, if the EU doesn't do it, I'm going to do it alone. And they rely on an authorization in EU acquis, in the import regulation, where it's said that you can do a national measure if you can claim this is part of your national policy or security. And in that matter, the states are claiming that because of the ICJ opinion, I am authorized to block trade with the settlements. So this is the situation we are currently having. And it's an ongoing discussion about the right or self-determination and how far does it oblige others to have these kind of measures. Of course, there are also the very, very tough problems about grave violations in the Israeli military campaign in Gaza. You have mentioned the case. We are waiting for the outcome of that case, and there were also very, very internal discussions whether or not the EU should react to atrocities committed during the Gaza campaign. And again, I have to say there was no majority in the councils between member states to suspend the agreement with Israel because of the campaign in Gaza. It was raised, it was discussed, but there was no majority to suspend the agreement with Israel on that matter. Okay, any questions on this one? Yes, please.
So I think that some countries, I think Spain and Belgium or Netherlands, now made those restrictions exactly. So how would that function under EU law? Would that be considered a breach of the EU trade obligations, or would one say, if we assume that there is this international obligation to actually restrict the trade, that that alone makes it actually illegal, and rather the EU trade regulation in that sense illegal?
You have pointed to a couple of member states who go now national, and I think I try to argue that this is normally not allowed under common commercial policy unless you have a specific authorization. And the specific authorization you can find in Article 24 of the EU import regulation, which says national measures can be taken when they are based on grounds of imperative national security or policy. And here those states can say, well, I think that I have an international law obligation to block the trade, so I'm going along, and that's a valid reason under Article 24 to do it. Okay, then I think we can move on. These were two very concrete and very important cases under Article 1, Paragraph 2 of the Charter, and then let's move on, and we can now ask ourselves, next principle in the Charter, if we go on reading, Article 1, Paragraph 3, what is that all about? Somebody can help us? Article 1, Paragraph 3 of the Charter. Yeah, the UN also is doing what? Yes, 1, Paragraph 3. Yeah, you read so nicely. Yes, please.
Article 1, Paragraph 3 of the Charter. To achieve international cooperation in solving international problems of an economic, social, cultural, and or humanitarian charter, and in the promotion and encouraging respect of human rights and for fundamental freedom for all without distinction as to race, sex, language, or religion.
So one purpose of the UN is to promote human rights with no distinction as to color, race, and other grounds. So what about a human rights policy, international policy? What does the EU do in that matter? I can probably give another lecture on that, but I have to be short. What we do have at EU level is an action plan for the promotion of human rights, which is also public, and says, okay, we are going to do campaigning, which means basically to support human rights defenders in third countries. So there is a lot of programs ongoing on this one, where the EU will give benefits to human rights defenders and trying also lawyers and advocates to defend people before court. And this is a very important part of our human rights policy. We also do dialogues with the governments, of course, human rights regular dialogues to address critical issues. And in the silent diplomacy of the human rights dialogues, what also happens now is sometimes to ask for the release of political prisoners. So this is happening more and more, which traditionally only national governments did, but the EU is engaging in that as well. And we also are looking to sanction human rights violators. So since a couple of years now, 2018-19, there is a specific sanctioning program of the EU for putting human rights violators on an EU sanctions list. And that means that person who is identified as a gross human rights violator cannot enter the European Union, and all the funds which are located on European banks are frozen, right? So this is a clear sign, and there is a list of people from a couple of states around the world who are somehow associated with gross human rights violations. For example, people who have killed demonstrators, peaceful demonstrators, or other gross abuses in parts of the country. And then it is also going against those who are personally responsible. So on the list you find high officials of ministries of interior or others who are identifiable as having given the orders for those gross atrocities. So it's a human rights instrument to sanction the violators. We also have a few who were involved in dealing with problems with the Uyghurs in China. And Chinese government was not pleased at all, and in return tried to sanction some European members of parliament. That was a fairly known diplomatic spat, but I think over time also the Chinese government is reconsidering whether that's the right approach to sanction European parliamentarians. So I think there could be movement on that front. Okay, so that's human rights policy. It's an important part of what we do in external relations, trying to promote human rights worldwide. And now let me come to another one, and that's quite how to say, legally difficult one, and that is the principle under Article 2.1 of the UN Charter. 2.1 is about sovereign equality of states. Sovereign equality of states, and that entails, in particular, the principle that one state cannot claim to be legally superior to another state. how can that happen if you are claiming to be legally superior, for example? If you allow your own courts to decide about matters which are not your business, right? So then you claim, oh, I can rule other states by simply allowing my courts to do that. Yeah? And so out of this principle, we have the sovereign equality means that no state can exercise jurisdiction over another state. Yeah? They are equal, everybody exercises jurisdiction about its own territory, but not about another one's. And this also brings us to the concept that we have mentioned this morning, immunity. There is immunity of states before the courts of another state, and there may be immunity of the president or the head of government before the state's courts of another one. Yeah? And there may be immunity also of state officials, but there we come into a very difficult area. Just to tell you that the equality of states leads to a couple of immunity-related sub-rules. And what is currently very important in the EU is the following, and I just want to mention it to be complete. In our sanctioning regime against the Russian Federation, because of the aggression against Ukraine, we have included the property of the Russian Central Bank. So, Russian Central Bank has a lot of money which is based in Europe. So there are estimates that they go 200 and more billion of euros. And they are located in European financial system. And after the invasion, one of the sanctions was to say no European bank or other operator is allowed to make business with the Russian Central Bank. So the money is there, but it cannot be moved. In other words, the money is immobilized. Russian Central Bank is still there. The Russian Central Bank is still the owner, but it cannot make anything with it. It cannot move it back. It is simply, catched, caught. And this raises a question under international law. Is that in line with immunity? What do you think? What could be arguments in favor or against? Any view on that? Let's say you now work for the Russian Central Bank and as legal advisor, and then your boss tells you, look, this cannot be true that the Europeans can just interfere with my property in this way. What could be your argument? Yes, sir?
Thank you. In that matter, it could not have been justice telling that you should not have interfere on my matter. It's for me, it's my view on that. But also, Professor, I want to make myself clear when you say that the European Union maybe cannot interfere with other states' matters. Is it only significant only to the judiciary or even parliamentary matters? Because there are examples that we saw recently. One among East African countries was discussed its matters through the European Parliament. Now, what does that stand in terms of immunity of the states? Thank you.
Okay, very good. So on our issue on immunity of the Russian Central Bank, you consider that as an interference and it should not be allowed under the law of immunity. And then you also raised the issue of interference in domestic matters by European Parliament. I think you have in mind the one recent case. I'm discussing the second one in a minute, so let's just finish the immunity issue. So the first issue here is the Russian Central Bank is acting for the Russian state. So it is an entity which is linked to the Russian state, so it is at least arguable to say the Russian Central Bank should, in principle, benefit also from immunity which are given to the Russian state, although it's a bank. Yeah? And that you can maybe also find in a UN Convention on Jurisdictional Immunities, where there is a provision that hints that direction. Next question is, okay, but is the Russian Central Bank really affected by this measure? Because it remains the owner. So normally, you would say there is an interference if somebody takes away your money. Is it enough to say, well, but I make sure that you cannot use it? So is there really an interference in the immunity? And that relates to the next question, which you have also raised in your question, in reply, sorry. It's not a measure of the judiciary. No European court did that. It's a matter of the legislation. The European Council did it. So even assuming that there would be interference, would the immunity extend to legislative action? Or does it only protect you against judicial action? Because the UN Convention is clearly about immunity before courts of another state. Yeah? And then finally, the question is also there, the EU measure is of course temporary. Yeah? It can be reversed anytime. So if tomorrow Russia stops the war, the Russian Central Bank gets the money back. So it's in the hands of Russia to make sure that it can get the money back. So all these points, just to tell you, it's fairly unsettled. Yeah? There's no clear answer, this question is now pending before European Court of Justice. The Russian Central Bank has brought a case and said, we think this is against international law, and the European Court of Justice will have to litigate that. And then in this case, of course, the institutions will defend that there is no breach of immunity. Now, coming to your question about European Parliament. So what's the matter here? European Parliament adopts a resolution in which it says, in African country X, we think there are a couple of human rights violations which we condemn. Okay? It's the resolution of the European Parliament which will address the human rights situation in an African country. Is this against the principle of sovereign equality and non-intervention under international law? That's the remark very validly posed. What do you think? Should it be allowed that one parliament makes an assessment about the human rights situation in another country? Any views on that? Yeah, I know your view. Maybe I will ask somebody who has a view here. Yes, who was it? Yeah, I just want to open the debate a little bit. Yeah, lady here to the right. Yeah.
I think that it can be kind of a slippery slope if you allow a parliament of like a completely different area to like, I guess, intrude on I think that would not, I think it would like kind of break the sovereignty rule. I feel like if the European Union or members of the Union were really concerned, they should go through like UN channels rather than deciding as the EU what's going on in a different continent. Because I guess at least with Russia, like they're kind of technically European.
Okay, so you find that this is somehow extraterritorial, And in order to address these kind of human rights problems, we have UN channels. Yeah? It's, of course, a respectable view. Now, I would first ask, what does the non-intervention principle legally mean exactly? Yeah? One state shall not intervene into the domestic affairs of another state. What is the legal, precise content of this? First issue is, what does the notion intervene mean? Intervention. And here we can look at the ICJ, which in the Nicaragua case had this issue before it. And in Nicaragua, ICJ said intervention means the employment of coercion, coercive measures, measures which are using, so to say, the possibility to exercise so much pressure that the other part is coerced to do something which it doesn't want to. Right? So the level is fairly high. Intervention is equated by the ICJ with coercive measures. Adopting a resolution which takes a view is not coercion. Right? It is maybe unfriendly, but it's certainly not coercion unless it would, and now we come to the situation, it would include legislation which would then have this coercive effect. Yeah? So there is discussion, for example, if European Parliament were to say, we don't like the human rights situation in country X, and therefore we are going to completely cut down all economic relations in order to make sure that the country changes its human rights policy. Then we come maybe in the area of coercion. But just saying we don't like it certainly is not coercion. Second, it says intervention in domestic affairs. That also legally is very important to understand for international lawyers. Domestic affairs does not mean everything you do at home. Domestic affairs means everything in which you as a state have not taken international obligations, so-called domaine réservé. But if you have taken international obligations, it's not a domestic matter, it has become an international matter. And on human rights, most of states have taken international obligations by ratifying the UN Covenant, or here, the African Human Rights Instrument. So a state is under obligation to accept human rights standards. And if then the European Parliament says, by the way, we think this is not in line with these standards that you yourself have ratified, it is also not an intervention in the domestic affairs. It's a matter of international concern. So therefore, I think it depends on the case. Yeah? But normally, if it's just a resolution on a matter where there are international human rights obligations existing, it would not breach the non-intervention principle. Please.
Thank you. So, basing on this principle you just explained, and if we link to the president of the Sahara state, can we say that the DRC Congo has a right to bring the cause of action against the European Union and at the European Court of Justice based on the EU MOU with Rwanda? Because we are aware that it's a public knowledge, and I, for one, have seen the MOU before, so it's not a conspiracy theory anymore. The European Union signed a memorandum of understanding with Rwanda to buy minerals from Rwanda, which are clear not found in Rwanda. These minerals are found in Congo. So we know what it means, receiving and abetting. Oh, gosh. Sorry, is it Rwanda who is trying to interfere in my network? So we are aware that these minerals are not found in Rwanda, they are found in Congo. So can you elaborate a bit on that? Thank you.
So the question is, in the situation described by Elvis, whether there could be a case brought against the European Union before the European Court of Justice. So that raises a couple of issues. First, who would be entitled to bring a claim? The DRC as a state. Okay, so then we would have to find out, does the DRC as a state have standing before the European Court of Justice? The answer is most likely yes, because the Court of Justice has already accepted that Venezuela can bring a case against the EU for sanctions against Venezuela. So this is accepted that a foreign state is a legal person within the meaning of Article 263 of the TFEU, so it would have standing, so it's DRC Congo. But the much more complicated question would be, what is the alleged violation? So you would say there is aiding and assisting of an illegal act, and you would have to show that this was instructed by European Union institutions. I cannot claim here ex urbi and orbi whether that's true or not, but I can only tell you that this claim has to be at least arguable, that there was a clear, I would say, international law violation by acts that can be attributed to the European Union. And I cannot say whether that's true or not, but these are the legal standards which would have to be invoked. Okay, good. So we were with the non-intervention principle. I think I replied to your question. And that brings me to something which is related and very interesting also. Sometimes the EU adopts not only resolutions, but sanctions. Sanctions against third countries, for example. In the Russia case, we will also make sure that there are certain Russian products not arriving on the EU territory anymore. Russian planes cannot land in European airports. Russian tankers cannot go into European ports, and so on. So there are very, very clear sanctions involved, which restrict the economic and financial relations. And here the question comes, Russia would say, these sanctions are clearly coercion, and they are therefore unilateral coercive measures. And as such, unilateral coercive measures are illegal, and they should only be taken by the UN Security Council. So this is a debate we have at the UN, and many states have been seized by the question. There are UN General Assembly resolutions on the matter that the use of unilateral coercive measures is illegal and should be avoided. So, UCMs, unilateral coercive measures. Are EU sanctions unilateral coercive measures? And here the answer would clearly be, it depends on the measure of coercion. And our opinion here is, coercion means if you would exercise the pressure to a certain degree that the other side has no other choice. Yeah? Whereas what we are doing here is to say, well, we put pressure, yes, we put pressure on Russia to stop the war, but by restricting the commercial exchanges with them. And Russia has absolutely no right to trade with the EU. There is no such right. And it is also not influencing the domestic politics or so, but it is a matter to say you should stop the war of aggression, and then it is an end. And therefore, in our view, and I of course defend it here, the EU sanctions do not qualify as unilateral coercive measures. They are falling below the threshold. And by the way, if you look at the Nicaragua case, there the question was about the American embargo against Nicaragua, and the court said no coercion. Yeah? So we are not even having a full embargo. We basically tackle something like 50% of the trade with the Russian Federation. So it's our conviction that there is not a problem. But it's true that at the UN level, a couple of states raised this as UCMs, which we think is not the case. Okay, So that leaves me to bring the last issue, and that is, so we discussed 2.1, and now let's briefly discuss 2.4, the prohibition on the use of force. We know what it is. Now after the lecture of Judge, you know all the details. So just a few words on the EU approach on that. So we are very clear that Article 2.4 is the cornerstone of international law. It is also confirmed to be use cogents character. And when you apply that to different situations, of course you have sometimes a bit of a doubt, but sometimes there's also clear-cut cases. First, Ukraine, Russia would be no surprise. The EU supported the UN General Assembly resolution of March 2022, where a huge majority of UN states agreed that this was an aggression which should be immediately stopped. So on that, no surprise. The other case we've just mentioned before, the Caribbean boats. I told you that we have doubts that there is an international armed conflict that allows shooting the drug boats. It's also a clear issue of 2.4. What about Venezuela, the abduction of President Maduro? Is there an international law justification for that? Well, the American position was this is law enforcement because he is indicted before a US federal court, and we can indict persons and then try to take them out to bring them to trial before US courts. What do you think about that?
As the head of state, he would still be immune from prosecution in another country, so there is no legal justification, and it was a case of intervention.
So under international criminal law, yes, you can indict also foreigners, that's all right, but you cannot exercise your jurisdiction on the soil of another state. Yeah, so that is a clear barrier, and therefore the theory to say this is just enforcement action on the territory of the third state does not hold in light of international criminal law, which brings us back to the other exceptions of Article 2.4. Was there UN Security Council authorization? No. Was there self-defense? No. So it's very hard to justify that action to be in line with international law, and the EU publicly said that whatever the US does with respect to Venezuela needs to comply with international law. And there you again can read, okay, we have doubts here, yeah, that there is a sufficient justification. And the last issue, of course, is Iran. Situation in Iran, what is international law analysis of this? Can somebody, yeah, maybe also somebody here? Yeah, I would like to open up the debate. It's your ability to say your view here. Yeah, yeah, a person here, behind the camera, Yes, you. You're just doing the camera. Okay, then it's your choice. All right.
So in that instance, the US is claiming to act in self-defense and that Iran would be preparing nuclear weapons, but there is not sufficient evidence that Iran is actually doing so, and also the self-defense would be preemptive. And in that regard, while I think some debate allows for preemptive measures of self-defense, that only applies to situations that are very, very close. But since it's debated whether they even, or very uncertain, working on a nuclear problem, that is not the case. So there's no self-defense, and it was an armed attack, an unprovoked attack.
I hope that other colleagues could follow the argument here. So the question in this context was, how far does Article 51 allow preventive action? yeah, or even preemptive. It's something you discussed a little bit with the judge. So there is accepted possibility of preventive self-defense with the so-called Carolina test. Yeah, if there is an immediate danger which you don't have to wait for to be attacked. If you can see that there's an immediate danger, you can start the hostilities, the Carolina test. But beyond that, there is then the debate, what about a preemptive attack? So not preventive, immediate danger, but preemptive, not to allow somebody to build up the capacity to destroy you, right? And this is a bit more controversial, and some people in doctrine are arguing that this is possible, especially when you would lose the possibility to defend yourself. Then you can have also the right for a preemptive fact. So in the case of Iran, the argument would be made to say, okay, once Iran has the capacity to really strike with an atomic bomb, it's too late. So I have to act before that, right? So I leave aside now whether or not this theory is sufficiently supported by state opinio juris. I leave this aside. But even if so, you will have to demonstrate that that's the case. And here the facts, how far the program of Iran has been matured to really give them capacity to strike. That, of course, is everybody can make its own conclusion. There may be facts which public doesn't know, right? But for that, what is publicly known, the advancement of the Iran nuclear program would have to be assessed in order to reply to that question. Okay. Well, I think we have now covered the second part. So the EU approach to some of the fundamental principles. We've looked at self-determination, looked at human rights, we looked at equality of states and non-intervention. We also looked at 2.4, and I think it gives you a little bit of a taste of where we stand. And after the break, we make the third pillar, and that's the contribution of the EU to the progressive development. So where things are moving and where we think the practice is bringing new concepts of international law, and I hope we can continue our discussion after the break. Thank you. I am happy to proceed with the third and final leg of this lecture, and it's anyway, it is not so long as the previous one, so I think we will survive together. And this goes into progressive development of international law. And I want to make a few examples where we think we are heading into this direction. And the first one is a fairly complicated one, but also super interesting. And that is the issue of the special tribunal for the crime of aggression against Ukraine. So, I'm not so sure whether you have heard about it already, but it is in the making. And starting point here is very clear. So after the invasion of Ukraine, there was a very large condemnation of the UN General Assembly. So by large, unanimous view is there was aggression, Russian aggression against Ukraine. Okay. But what follows from that, legally speaking? Legally speaking, number one, the state, the Russian Federation, is on an obligation to stop it. Okay? Second, the Russian Federation is also on an obligation to repair war damages. And we'll discuss that in a minute. And then comes the third thing, also very interesting. Is there anything such as criminal responsibility? Can one say that those who are engaged in the Russian aggression bear criminal responsibility? Yes or no? Yes, and why? Who is saying? Yeah. Okay. Okay, tell me.
Completely violation of human rights and basically human rights and international, some of the international protocols, although I'm not an international guy, so I'm trying to see it in intuitive perspective. Thank you.
Okay, so violation of human rights, but then my next observation would be, does that lead to criminal accountability? So if somebody violates human rights of somebody else, does that mean automatically that you're criminal liable? Yes?
So violation of human rights usually does not entail individual criminal liability, but what we do have in the case of Russia is a violation of war crimes, at least, and crimes against humanity.
Okay, so we are going into war crimes, crimes against humanity, which, interestingly, in the African Constitutive Act are the grounds for intervention. You remember, 4H. So this will lead to individual criminal responsibility, correct. If you look at the ICC statute, you have the atrocity crimes, and they clearly say whoever commits a war crime or a crime against humanity is personally criminal responsible, and usually the state of nationality should investigate, but in this case Russian Federation will not do it. So ICC may become responsible. And this is what happened actually. A couple of states referred the situation in Ukraine to the ICC, and the ICC started investigations and indicted a couple of Russian responsibles, in particular on war crimes and crimes against humanity, including President Putin. So this is clear and it is running. It's in the ICC, an ongoing investigation. But my question was, is there criminal accountability for the aggression as such? The war crime would mean during the attacks on Ukraine, there will be attacks on civilians which are not justified, war crime. There may be a widespread campaign against civilian population if the facts can show that, crime against humanity. But the very fact of having attacked Ukraine in the beginning, is that as such a crime in itself? Yes?
Alors, je ne sais pas si on peut qualifier ça comme tel, comme un acte criminel, mais quand même, je pense que les statuts de Rome qui créent la Cour pénale internationale a prévu qu'il y ait également les crimes d'agression, lesquels crimes également peuvent être poursuivis les hauts dirigeants, comme moi je prends l'exemple de Poutine, et où, bon, bien sûr, il est là, il a commis, et il faut que ce soit d'abord le Conseil de sécurité qui puisse d'abord qualifier qu'il y a d'abord agression avant que Poutine puisse être inculpé directement des crimes d'agression.
Okay, again, very good answer. So, if we look at the Rome Statute, we will see that the crime of aggression is a self-standing crime. It's Article 8 bis of the statute, and it was added in the Kampala Amendment 2010. Yeah? So we have a definition of the crime of aggression, and it will say each act of aggression constitutes a crime of aggression if it is a crime committed by the leaders, so those who have the responsibility and the possibility to decide, and if it is particular grave breach of the UN Charter. And both conditions are fulfilled here. It's a particular grave breach to send your army almost a million soldiers in order to annex part of your neighboring country, no doubt about it. And it is also a crime committed by the leaders, President Putin and his ministers, Minister of Defense and the high-ranking generals. We know who they are, and they have committed the crime of aggression. So answer is yes, they are individual criminal responsible. But, as rightly said by a colleague here, the ICC does not investigate for crimes of investment. Why does they not investigate? They investigate war crimes and also crime against humanity, but they do not investigate the crime of aggression. Why is that so? Because the very same Rome Statute has specific procedural norms for the crime of aggression. The other three atrocity crimes can be prosecuted by the prosecutor bringing itself an investigation, whereas for the crime of aggression, there is a specific condition which says either the Security Council refers the situation to the ICC, which will never happen, Russia will not allow that, or both states are party to the Rome Statute, both the aggressor and the victim. Russia has not ratified the Rome Statute, so they cannot be investigated. Therefore, ICC is not doing anything on the crime of aggression, although, obviously, it has been committed. This raises the question, should we accept that? Should we simply say, well, that's the state of international law, this is how far states have been able to agree, yeah, in Kampala that was the agreement, and we have to live with this. Or would we say, it does not really make sense that the ICC can investigate war crimes, but the even more serious one, the act of aggression which has allowed all subsequent war crimes, can be untouched. And so inside the European Union, but also some other states outside, so Australia, UK, and the Biden administration, they all came to the same conclusion. We cannot simply accept that. We need to make sure that there is an effective mechanism to address also the crime of aggression as such. And this led to negotiations over 2 years, and I've been part of them, to come up with a statute, a new legal text for a special tribunal which would look only at the aggression of the Russian Federation against Ukraine. And this statute has been negotiated in an informal way, but is now public because it has been concluded between the Ukraine and the Council of Europe. So not the European Union, but the Council of Europe. Council of Europe is the other European organization which has more than 40 members, and it includes also states such as Turkey, Serbia, Georgia, and so on. So it's the broader European regional organization, and the Council of Europe and Ukraine have agreed to adopt this as an international treaty. So there is a new international treaty establishing the tribunal. And it will come into force when there will be sufficient number of states who then, in the next step, will agree to collaborate with the tribunal by giving judges, financing, and collaboration. So if ever there is a person to be caught, that then all those states will collaborate with the special tribunal and render the person to The Hague. So it's in the making. The statute is there, but the final step, let's say the administrative part, is still going on. So maybe in 1-2 years we will have it. Now what is interesting for us here in the room is how does the special tribunal deal with two questions. First question is applicable law. So for which crime can the persons then be sentenced? We talked about Article 8 bis. It's It's in the Rome Statute. But does it also mean that the same provision will be applied by a special tribunal? Or will the special tribunal apply Ukrainian law? Because after all, the crime is happening in Ukraine, and Ukraine has a provision which says aggression is criminal. Yeah? So there would be a choice to be made. Ukrainian law, domestic law, will be applicable law, or Article 8 bis. And there was a huge kind of controversy around this, and it has to do with the fact that you need to understand first, where does the jurisdiction come from, the new tribunal? Yeah? Why can the Council of Europe and Ukraine simply set up a tribunal which are sitting over Russian leaders? Russia has not consented. So where does the jurisdiction come from? And the answer is the jurisdiction comes from the territorial jurisdiction of Ukraine as a victim of aggression. And they can ask the Council of Europe to help them in establishing this new special tribunal. So territorial jurisdiction would speak in favor of applying Ukrainian law. At the same time, you also don't want to make it a pure Ukrainian business. Because if it is a pure Ukrainian business, they could also ask their own domestic court. They could say, well, we go, and the Supreme Court of Ukraine will have a special chamber on criminal jurisdiction, and then they could do it on their own. You don't need an international tribunal for that. The whole purpose of a special tribunal would be to bring in international judges which will apply international law, right? So from that perspective, it is more convenient or more logical to say the tribunal should apply Article 8 bis of the Rome Statute and not Ukrainian domestic law, you see? And in the discussions we had, we came down at the end to say, well, we were going to refer to Article 8 bis, tel quel, but with one nuance. In Article 8 bis of the Rome Statute, you have a paragraph 2 which says acts of aggression are in particular, and then have a long list. And it was decided to leave this out and simply say, in this case, acts of aggression shall be interpreted in line with the relevant UN General Assembly resolutions, including those which have already found an aggression in February 2022. So, in short, applicable law is Article bis, but with the perspective of applying it to the situation in Ukraine. So that's already a novelty, yeah, a very interesting one, that you have a new tribunal with the Council of Europe which will apply Article 8 bis. Next question, maybe even more complicated one, is what are the procedural rules that this new tribunal will apply? We have discussed the Bashir case. So in Bashir, position of African Union states was ICC, you shall not prosecute al-Bashir as long as he is a sitting president, because he enjoys immunity, even for grave crimes. Immunity is more important than prosecution of grave crimes. That was the position of African Union for this case. The ICC itself, in the al-Bashir decision, said no, there is a customary international law rule which says for the worst crimes, including crimes against humanity but also aggression, there is no immunity before an international court, and I, the ICC, I'm an international court. So I have the jurisdiction over Bashir, whether or not he's sitting president doesn't matter. This position of the ICC, however, is contested. You heard this morning even Judge Flati said he's not in agreement with that. Yeah, the counter view is to say, well, immunity still applies, but states can waive the immunity. So all states who have ratified the Rome Statute have agreed that there's no immunity for the heads of state. But states who have not ratified the Rome Statute, they can still rely on immunity for the heads of states. So in this case, transposed to the Russian situation, if you take the second view, you would come to the conclusion Russia has never ratified the Rome Statute. They have never waived the immunity of the sitting head of state. They certainly have not ratified this special tribunal treaty. So immunity is still alive. Yeah? And depending on which view you take, yeah, you come to a completely different result. If you say it's customary law, no problem with immunity. If you say, well, it needs to be waived, then you need to find a solution. And on that one, the statute is quite interesting, because if you look at it, we can unfortunately not have the time to go into all the details, but you can see it in the statute. We make a distinction. So all the states who will support the special tribunal have come to the following conclusion. During the investigation by an independent prosecutor, there is no immunity. So in other words, a prosecutor can start investigating, bringing the facts, analyzing the facts, writing an indictment, and make an indictment to the court. That is all possible. But once the indictment arrives with the court has to check who is indicted. If the person who is indicted is a sitting president, I have to suspend the proceeding as long as the person is still in office. Once the person leaves office, there's no immunity anymore, and the trial can go ahead. So you see, this is a kind of in-between, between the two positions. One position says immunity is not a problem, and the other position which says immunity shields from any criminal prosecution. Here we says no, you can investigate, but you cannot try as long as the person is in office. And this is something which probably people will look at when they will have an assessment of the immunity question nowadays. Of course, one can have different views, whether that's good or bad, but this is the latest on the matter. Those states who said, well, I'm not so really happy that this is a good solution for international law at large, insisted, nevertheless, that in the statute there is another clause, Article 5, which says nothing in this statute shall be read as being a customary issue. So it shall not be construed as opinio juris in one way or the other. Okay? So there is a caveat whether this can really inform international law, the state of international law. But on the other hand, it's also clear for that special tribunal, this will be the applicable rule, and once there would be an indictment delivered, it has to be applied. Final question, how realistic is it that you ever have a Russian defendant coming to The Hague? It sounds a little bit illusionary. Currently, that you can get one of those who are currently in power. Well, you never know. If there is a change, it can go very quickly. If you remember Milosevic case, who was the president of Serbia and Montenegro, and at the time when the ICTY was founded in 1995, everybody thought this is for nothing. Yeah, you can maybe get the subordinate people, but never the top. And then all of a sudden there was a change in Belgrade, and within half a year Milosevic was in The Hague and died there, actually. He was not hanged, but he died in prison. So one should not underestimate these kind of things. And on top of it, once the tribunal is there will be a possibility to also indict not only the highest, but also the senior leaders, so army generals and others. And you never know whether or not one or the other will wish to leave Russia at a certain stage. We don't know, right? And in any case, it is also foreseen, and that's the last point here, and the tribunal has the right to make a sentence in absentia, so the defendant doesn't have to be there in person, but all the conditions of fair trial under the jurisprudence of the European Court of Human Rights need to be applied. So European Court of Human Rights has accepted that trials in absentia are in line with due process, provided that the person has been duly notified, has in his absence a lawyer, and has the possibility to come anytime. And when the person will then come, you start from the beginning. So, I just give this to your attention because I assume that you have not heard about it, or at least only the word. It's a new instrument of international law, Special Tribunal on the Crime of Aggression, and it will certainly be very important in the coming years, and it has these interesting legal concepts. Any question on that? Yes, please.
Thank you very much. As we know, the relationship from the European states with Russia and Israel are different right now. Is there any position from the European Union regarding if Netanyahu or Putin or other people that there is an order of arrest by the International Court of International Criminal Court visits one of the European countries? Is there any position in that regard?
Okay, so the position of the EU with respect to ICC in general is very clear. We fully support the ICC, and every member state is expected to honor its commitments. So there is an indictment against the Prime Minister of Israel, not for aggression, but for other crimes. And if he were to set foot into one of the EU member states, under the Rome Statute, the member state is obliged to arrest him. So that's pretty straightforward. If hypothetically a member state would not do so, right, what could be the possibility of the EU in this kind of respect? This would be highly political. There's not much we can change this behavior, but I would argue this would run against also European law principles, because the commitment to apply ICC statute translates also to European law matter, and then we would have to assess it on that basis. Yeah? Okay, good. So, Special Tribunal, quite an interesting bit. Now, next one I was mentioning was the duty to pay reparations. Yeah? So after the Russian attack and unfortunately ongoing attacks, the destruction of property, lives, and others is ongoing. And there are a lot of war crimes involved. Yeah? And it does not only mean criminal responsibility, it also means there is state responsibility for the internationally wrongful acts, and they require compensation, war reparations. Yeah? You know that from history, that after big conflicts, normally there is some sort of settlement of the war claims and war reparations. Now, in this case, again, there is some of a novel approach here, because we have started to look at the matter already now, before the war is over. So, the European Union member states, plus, again, a coalition of the willing, have negotiated an instrument which is based on a UN General Assembly resolution, which was saying that let's start with a register of claims. UN General Assembly resolution of October 2022. It would be good to have, as a first step, a register of claims, where Ukrainian victims, private persons, state authorities, groups, can say, my house was bombed. Here I have a proof it was worth 100,000 euros, and I want to have reparation. This is just a claim. But somebody needs to collect these claims. And if we are in a very broad-scale conflict, these claims go into the thousands. So I can tell you in the register of claims currently are 180,000 claims pending from persons who have been damaged. But this is only a register. You say, okay, I am going to put this into a file under your name, and I'm going to secure the evidence. Very important, to secure the evidence. But it's not enough. What is then the next step? Once you have registered, somebody needs to decide whether or not this is a correct claim, whether you can actually agree with the claim. Who should be that person who decides on those claims? What do you think? Normally, yes, sir, on the back.
I just want to respond to what you have asked me, and then you can tell me whether I'm right or wrong. I think it's Russia maybe is trying to cool down the pressure, but I have a follow-up question to your presentation. You have said that you are registering those claims for the properties, but to my understanding, there is no value for those lost lives. How are you going to compensate them? That is totally ridiculous, because once you have human beings who are alive, they are the capital for a leader to collect tax and run the government. So to me, I think it's totally ridiculous to register the properties while you cannot register people's, and people are not valued at all cost. Maybe I can ask you, what is the value of a human being at all? And then following up, maybe you can just tell us, apart from all violation of human rights and other stuff, what are the really driving factors for the conflict between Russia and Ukraine? Is it because of resources, or is it just like attention, or political, or something like that? Thank you. I think I have a couple of questions. Maybe you can try to analyze them.
Now, very, very good. First point that colleague has raised is it seems unjust to register claims for property, but what about the lost lives? There may be victims who have simply been killed. Are they not equally valid or even more, right? And the answer is yes, of course they can be registered. So I just made an example. Yeah, you can register claims for all losses which are based on a war crime or an attack which is not justified under international law, including the loss of lives. The quantification of how much compensation you get for that is a matter of the deciding body, and that was my first question. Who's going to decide about these claims? Yeah? And the answer here is it will have to be an international body. So again, not a Ukrainian domestic, but an international body. And for that purpose, there was a negotiating on a new convention establishing an international claims commission. And that was signed in December last year. So we have a new international convention establishing a claims commission, and in the claims commission you will have international experts, which are then called commissioners, in particular panels, and they will have the power, 3 panelists together, to decide upon a claim. And they will then have a methodology how to value property, lives, but also grave other damages on the body and what have you. There are different categories of claims which can be made. And this will be in the hands of these claims commissioners, which will be appointed by all the ratifying states. For the time being, we have over 30 states who have signed the convention, and the ratifications are coming in. The European Union itself has ratified that convention already. Now, to your other question, sir, what are the background of the entire conflict? So why did the conflict arise between Russia and Ukraine. I already said yesterday, probably in another session, that I don't think that is a fight about minerals or something. There may be one of the motivation to go for Donbass because they have good minerals, but the overwhelming reason, and it's also in public speeches of the president and others, is the restoration of the Russian zone of state, based on the assumption that Ukraine as an independent state should not exist because there is no independent Ukraine people. If you consider, like President Putin, that Ukrainians are in reality Russians, yeah, you simply deny their right to self-determination and say this is part of ours, end of story. And the military attempts were not directed only at the Donbass. Let's not be mistaken. In the very first 2 weeks of the invasion, they attacked Kiev, tried to get the airport of Kiev and to topple the government. So if the Russian invasion had been successful in the first 2 weeks, they would have gotten Zelensky out, taken over the power, and made the entire Ukraine part of Russia. So let's not be mistaken that this is about minerals in the Donbass. This is about much more, and that is why also the other neighboring states are very, very concerned. This is an imperialist war, and this is has nothing, not maybe nothing, but not driven by the quest for minerals. Okay, now I have to follow up a little bit. Claim commissioners will be established by those who ratify the treaty, but then the final question is, where does the money come from? Yeah, let's imagine these claim commissioners will say, yeah, you have a claim for your lost property, and this is valid, maybe not 100,000, but 50,000 euros. Where does the money come from? And this is the open question, which for the time being is not yet decided. Clearly, under the law of responsibility, it must be the Russian Federation who pays. As long as the war is ongoing and then there's no ceasefire or even peace agreement, the Russian Federation does not consent to it. But the hope is that with a new international agreement that ends the war, that this issue will also be settled. That's for the future. You have a question, sir?
Professeur, je rebondis un peu sur ce que vous avez dit en dernier sur la question de réparation concernant le conflit Ukraine-Russie. Le problème se pose, je pense, par rapport au fonds, comment il va être collecté pour réparer ou les effets de cette guerre. Dernièrement, je pense que devant l'Union européenne, il y avait cette question qui a été posée. Est-ce qu'on peut utiliser les fonds gelés, les fonds de la Russie gelés, et ça n'a pas trouvé un consensus entre les pays de l'Union européenne. Ça, c'est juste pour rebondir. Il y avait une question qui a été posée, ou une suggestion qui a été posée. Est-ce qu'on peut utiliser les intérêts un peu de ces flux financiers gelés devant l'Union européenne? Ça, c'est pour rebondir. Vous pouvez en donner plus, mais ma question précise, il y a dans le droit international, plutôt dans la communauté internationale, dans ces conflits internationaux, il y a matière à réflexion concernant des fonds gelés qui concernent des personnes physiques. Non seulement dans le cadre de cette guerre Ukraine-Russie, mais dans d'autres cas, il y a des personnes physiques en Afrique, en Russie, dans d'autres pays, en Amérique latine, qui voient leur compte gelé. Le dernier cas, c'est les juges de la Cour pénale internationale. Et donc, qu'est-ce que propose le droit international? Est-ce que ces personnes ne se voient pas un peu interdire d'accès à la justice pour réclamer la levée de ces sanctions concernant des personnes physiques par rapport à des conflits qui concernent les pays, des États ou autres. Voilà.
All right, these were a couple of interesting thoughts, and I try to summarize them. So first question was, in order to pay these compensations, is it not possible to use the frozen Russian assets? Right? I told you about the immobilization of the Russian central bank assets, and then the next question was, okay, can we not use it for compensating the victims? This is an open political discussion, right? Legally speaking, it would mean that you are not just immobilizing the money, but you are spending it, right? So you cannot give it back to Russia at the end of the conflict because you have spent it. And therefore the use of the assets need to be justified, and I'm leaving at this. It's an open question whether it can be done or not. Second, you rightly said there are also sanctions against individual persons whose assets are frozen, and here EU sanctions against those persons will be lifted once they would not support the Russian regime anymore, and then they get their money back, no problem. Whereas in the case of ICC judges who are sanctioned by the United States, we think there is no legal justification for that in the first place. If you do your job at the ICC, you cannot be sanctioned by the US administration, basically on a legal ground which is not there, because an ICC judge is not intervening in US domestic affairs, but is doing an international mandate. So I would distinguish between those two cases. Yeah? Okay, but very interesting discussion here on the Claims Commission. There's this ongoing developments, and maybe in 1-2 years we will know more about the financing of those, but the very fact that the Claims Commission has been already established by an international treaty shows you that we are trying to push in that direction on further progressive evolution of international law. And then my final point for today is, again, has to do with the sanctions. So I told you that the EU has adopted a couple of sanctions against the Russian Federation, also economically. Among them are transport sanctions. Russian transport is not allowed into the EU anymore. So if you want to go out of Moscow, you have to fly to Istanbul or somewhere else, but not to a European citizen. And here the question comes, is this justified under ICAO rules, International Civil Aviation Organization rules? And the Russian Federation contests that and has brought a case against over 30 states in ICAO Council, arguing that the transport sanctions against the Russian Federation are violating the ICAO constitution, the Chicago Convention of 44. And that will be a very interesting case also to follow from an international law point of view, because you will have to argue that under the Chicago Convention there is an international security exception. That for reasons of international security, peace and security, it is possible to adopt these kind of measures. We will see whether this will be justified. And on top of it, you can go into issues of customary international law by asking the question, is it possible to construe these kind of measures as countermeasures against the Russian aggression on Ukraine? So can we say, for example, EU would say, well, I have to restrict the travel between Russia and the EU because I want you to stop the war in Ukraine as a countermeasure. And this raises the question, can a countermeasure be applied by a state or the EU if it is not the victim of the attack in the first place? Yeah? The victim is Ukraine. So Ukraine can always say, I am not going to honor my obligations vis-à-vis Russia as a countermeasure. No problem. But can the EU or any other third state say, I'm going to apply a countermeasure against Russia because it violates Ukraine? And this raises a question which international lawyers would qualify as countermeasures for the breach of erga omnes norms. What do I mean with that? I mean with that the prohibition on the use of force and the prohibition of aggression is not only jus cogens, but is also erga omnes. It means that it concerns all states and not only the victim state. And if you take this thought further, you will say, well, if the violation concerns all states, then also all states are entitled to take countermeasures under the strict limits of those countermeasures, of course, temporary reversal and so on and so on. So I bring this to your attention because it's another open question, interesting one, which we'll have to discuss in due course. All right. Dear participants, ladies and gentlemen, I think I've come to my end. It was really an honor and a great pleasure to be able to discuss with you. I hope one of the other ideas that I've presented were also convincing, but if not, never mind, I can take that, no problem. In any case, I wish you all success for your future careers, and I've heard a lot of brilliant interventions, so I'm super happy to have been there and would like to thank you for your great cooperation. Thank you.
Let us give him more flowers, please. At this moment, I'd like to invite Professor Dr. Matthias Sinkuye. While we are waiting for Prof to come, maybe we have one or two questions.
Okay, I would just like to hear more about the specific enforcement measures that are used when getting reparations or making the perpetrator country pay reparations.
Thank you very much, Prof, for your presentation. And for me, I would like to know your observation on this rising sort of special tribunals for specific mandates, like the one of Kosovo, and now you are telling us this of the Ukraine. And UN saw that this having special, mandated like tribunals is very costful. But now I see the trend is like we are going back. Don't you think that this is going to be costful in the future? And like there should be something that will solve this into one international court, that is the ICC, for instance.
Yeah, thanks a lot. I will start with the first question on the enforcement mechanism. So this is what I said, the so-called third phase. Yeah. So once you have decisions of the Commission, who is going to enforce them? And the best scenario would be you have a peace treaty in the future. The Russian Federation agrees to pay war compensation, and then there's no problem. If it doesn't happen this way, and we are later down the road without a satisfactory solution on that, member states will have to see whether they can use other means, such as Russian assets abroad or Russian revenue or whatever. But as I said, this is really very much in the flux. I cannot give a definite answer today. This is open for future developments. On your question about the trend of having extra tribunals in the relation to ICC, our position is very clear. The Kosovo Specialized Chambers was asked by Kosovo as part of the EU accession course also, and is financed by the EU, right? So, and it will come to an end. It is, when the main cases are over, it will be resolved and it will disappear. For the special tribunal, the idea is not to have a competitive institution for the ICC, but to address this problem of lacking jurisdiction of the ICC on aggression against the P5. So this is the whole purpose, and maybe you can solve this by also changing the statute of the ICC itself and removing the exception for the act of aggression, that you say, well, even for aggression, the prosecution can go ahead without Security Council or without being both parties member of the ICC. But for that you need a formal treaty amendment, and some states have already made that proposal. So there is a proposal pending on ICC reform to address this issue. If that reform would go through, certainly we would not need any such of these special tribunals in the future anymore.
Thank you very much. I see Professor Matthias Sinkwe is ready, so I would now like to invite Prof, please.
Thank you very much. Good afternoon, everybody. Thank you, Frank. You know, there was a time as we were preparing this program, there was a time I had despaired because I had a program with topics, but those topics did not have anyone to cover them. So I started panicking as the date of the academy was approaching.